All right, the time is now 4 o'clock, and I'd like to call this session of the Court of Revision into order. Are there any disclosures of pecuniary interest among the group? None seen. I'd like to read our land acknowledgement. We acknowledge that the ground on which we live is the traditional territory of the Caldwell First Nation, of the Three Fires of Confederacy, and the original people of Point Pelee and Pelee Island, and its surrounding lands and waters, and that of the Huron, Wendat, and Wyandot peoples. We recognize and respect the First Nations, who are stewards of the land and waters of Turtle Island, and who have embraced the stewardship since the time of immemorial. We would also like to acknowledge the contributions of other nearby First Nation communities and all other original peoples across Turtle Island. The purpose of the Court of Revision is to hear the appeals to the charges being assessed to individual property owners as outlined in the schedule of assessments contained in the engineer's report for the repair and improvement of the Chappus drain. Submissions related to the technical merits of the engineer's report are not permitted. Michael Capucci, the manager of engineering with the town of LaSalle, will provide an update regarding the addendum to the construction schedule of the assessment. Michael.
Thank you. Thanks for everyone for coming today. I just wanted to give a brief overview of the project and kind of discuss a small little hiccup we have with the construction schedule. So, as most of you here know, there are two parts to this drainage report. One of them is the maintenance schedule of assessments, and the other one is the construction assessment. And during the comment period for the Court of Revision, administration noticed a slight issue with some of the properties that front Golf View Drive. Most notably that their assessments were too high. So as part of this process, we noticed it, but it was too late to make any changes. So what the plan going forward is, since the Golf View Drive property owners were assessed too high, their assessment needs to be properly adjusted. And those costs need to be absorbed by the upstream landowners, where the cost should have originally been fallen into the original landowners upstream. To properly fix this, we will be sending out an amended schedule of assessment to all the impacted landowners. So in this case, only the residents, only the property owners within the construction schedule of assessments will get notified of their new essential assessment to their property, and there'll be a second Court of Revision at a further date. So that doesn't stop anyone from speaking tonight, or their appeals can still be heard under this court. But for those under the construction assessment north of Golfview, there will be a slight modification to their assessment. As for the maintenance schedule goes unchanged. There was no issues found there. It was just for the construction portion. So I think that kind of gives a brief overview of some of the issues we found and the minor change that's going to be coming after this court adjourns.
Thank you, Michael. The sitting of the Court of Revision is pursuant to the engineer's report prepared by Root Engineering Incorporated, which was dated April 18th, 2023. The town received a number of appeals that were withdrawn, and I would like to read them out now. The landowner of Plan 834, Lot 59 to 64, submitted an appeal and has been withdrawn. Landowner of parcel number 3729 500-000-32300 submitted an appeal, and it has been since withdrawn or resolved. Landowner of parcel number 373415000010 has submitted an appeal, and the appeal has either been resolved or withdrawn. Landowner of parcel number 37295000003230 has submitted an appeal, and the appeal has been resolved or withdrawn. The town received two appeals that were not withdrawn, and the names of the appellants, we'll start with Elaine Pierce. Is Elaine Pierce in the audience? Would you like to approach and state your name again? And this is your opportunity to state your case.
Okay. I'm Elaine Pierce. I'm on Match It, and I feel my assessment's a little too high. And also, our town, to me, is double dipping. On the news, on November 7th, they announced that all LaSalle residents' taxes will be increased at least $300 to $400 more this year for policing, fire, and municipal drain maintenance. So how can they raise our taxes for municipal drain maintenance plus charge us individually for this? And all the properties around me, there's a lot beside me that it runs right from Malden Road to Match It. It's 66 feet wide. It's appraised less than my property. Now that's a lot more acreage than I have. Why is that lot appraised a lot less? Is it because the town owns it?
Michael, can you speak to the first thing of the drainage works that will result in the increased taxes?
So yes, thank you. So I'm not too sure about that. Was it a news article or?
CKLW.
CKLW. So the Drainage Act is found all over Ontario, one of the oldest legislations, and essentially property owners are responsible for the water that falls onto their property to viable outlet. The town doesn't pay for drainage maintenance unless they're assessed. So we have properties in here on the right of way that we're assessed, just like your property is assessed. So you get taxed solely based on the water that's produced and outletted into the drain. And the town doesn't pay for these types of projects. It's not a town capital job. So I'm not too sure exactly what that news article was trying to refer to. This has been our standard practice for some time now to follow the act, and the homeowners get assessed. So I'm not too sure about that. I can say that the overall project cost and construction schedule, maybe sometimes that helped. We are planning on doing it in 2024. You would likely not see it built to early 25. Just to have some information regarding construction schedule and costs coming down, potential costs in the future.
Thank you, Michael. I also will make note that this property falls into what Michael alluded to at the very beginning, that it'll be reassessed based on new leak conditions.
Yeah, but will it be assessed more or less?
I don't have that information. I don't know if the administration can comment on that.
I don't want to kind of blur the lines here. I think we should address this issue as the current assessment schedule. You have the opportunity to appeal the next part, and we can talk about that later. I just feel that if we start talking about potential future assessments, it might get confusing, and we can talk about that after. I just don't want this court to have to.
Because back in July, when we first got the notices, and I had spoke to the town about it, they told me my assessment was gonna be like 318. Now it's way up to 422. Then where's it going after that? Up even more?
Like I said, I don't want to talk about, we can discuss that. It's just at the next court. I think we want to resolve, if you have any issues with this assessment schedule today, when you get the new assessment schedule, we'll have the updated costs and we can have a more thorough discussion about it because we'll know exactly what the costs we're talking about.
Because like I say, I was told one price earlier, and then when I got the paperwork, it was higher than what I was told.
I will, like I said, I understand that you might have had gotten the wrong information, but we'll be able to give you the updated costs on the updated assessment schedule. Like I said, we want it to be clear and transparent that there was an issue with the original one. I don't want to start discussing those costs here because they haven't been presented to all the property owners officially. So it would be, like I said, it'd be cleaner if that question gets assessed when we send out the new letter.
Thank you, Michael.
Yeah.
I would like to ask our engineer if he would like to comment on the merits of this particular plot. Please state your name and turn on the mic.
Thank you, Mr. Chairman. Gerard Root. I prepared the drainage report for the project. With regards to the lady's appeal here, the property is located on Matchett Road, just north of Pitkin Avenue. And when I reviewed the concern after receiving the appeal, I found that all of her rates are similar to adjacent properties around her. And one of the reasons for her cost is that she is upstream from about half of the works in the drainage system. So when the drain is repaired and improved, she has that responsibility for that portion of the work that's located downstream of where her water will enter the drains. So I cannot see any justifications for changes or adjustment to her schedule in the current report assessment schedule for construction work.
Thank you very much. I'll ask the court members if there's any comment or questions. None seen. Okay, I'll ask the court for a motion to either deliberate or to end this portion of the meeting or consider reducing this right now. So you get a motion.
Excuse me, Mr. Soulier. We will hear all the appeals, and then we will deliberate all of them all at once. Thank you.
Okay, pardon me. I'll ask Elaine for any final comment.
No, I guess not. I knew exactly where it was going to go, so,
Okay, thank you very much.
yeah.
Is there a Marcel Bizarre in the audience? Unseen. I do acknowledge that there are other audience members. Is there anybody in the audience that would like to come forward with a late appeal that missed the 10-day deadline? None seen. So at this point, I would like to ask for a motion from the court.
Sorry. The second, would you be able to read and deliberate the second appellant? And have Gerard speak to the appeal, yeah.
Mr. Roux, would you comment on the second appeal from Marcel Bizarre?
Through you, Mr. Chairman. So the owner questioned that he had done tiling work to his farm that may have changed his drainage outlet. Our assessment was based on the original areas assessed to the Chappus drain from the past reports, and there was never any input during the Public Information Center meetings or consideration meetings for any changes required to the amount of area that's being assessed. The other factor that comes into play is that Mr. Bezier mentioned that his drainage was going through the county road drain, and typically the county does not permit any kind of public access into their drains for discharging of their flows or diverting the drains. So there would have to be some kind of investigations or information provided that there's an actual agreement between the county and the property owner that would allow him to take his flows out the way that he had his tiling done, possibly without any permission received to actually do that. So his legal outlet, as far as the information we have, is still through the Chappus drain based on the historical affected area that's approximately half of his land property that was always determined to be coming towards the Chappus drain for its available outlet, and I cannot recommend any change to the affected area in the parcel just because he claims now that he's done some kind of drainage that diverted the underground portion of the drainage away from the Chappus drain, but there's no information to prove that any surface flows or anything are redirected, so that the original property area should still remain assessed into the Chappus drain as established in the past reports and as we provided for with no questions or concerns during any of the previous meetings that we had.
Thank you very much. I'd like to ask the court if there's any other comments or questions for administration or Mr. Rood.
One question for Mr. Rood. So you're telling me that he's done this sloping of his land or so on and so forth. Was that done before or after the construction?
I don't recall seeing a date or anything in that appeal that he submitted. From the description that was there, it sounds like he did that more recently, which would be after the previous report. But as I mentioned, there's no documentation or anything to show that he has legally gotten the rights to divert any kind of the drainage. And just tile drainage is only about 1/3 of the overall drainage, and it's only for a small portion of his property that he's asking to possibly be exempted from, but without any kind of documentation for that being made available, there's no way that we can make a recommendation for any variation or changes from how it's always been assessed in the past.
Thank you.
Has administration received any notification of the works that are in question from Mr. Bezier?
No, we're not aware of any.
Does administration have any last comments before I ask for a motion?
No.
Okay, I'll ask the court for a motion to deliberate these two appeals in private, or to and send them a notification after our decision, or deliberate live.
I move that we moved to deliberate.
I'll second that.
Okay, we will move to deliberate, and this will conclude today's meeting, and the appellants will receive their our decision by mail. Thank you very much. Can I get a motion to adjourn the meeting?
Second now.
Second.
Thank you very much.
Meeting adjourned.
Meeting adjourned.